All right, guys, welcome to the NRA and CRPA webinar regarding ghost guns, specifically Assembly Bill 857 and DOJ's regulations, which were just recently released. My name is Matthew Cabero. I am an attorney with Michelle & Associates in Long Beach, California. With us today is, from our office, is Grace. She is the chairperson of the meeting. She is assisting us in putting this together. Thank you, Grace, for everything that you've done on this. This webinar also produced by the National Rifle Association of America and the California Rifle and Pistol Association. And with us today, Dan Reed, the Western Regional Director of the National Rifle Association. Dan?
Matt, thank you so much for having me on, and thank you to everyone in your shop over at Michelle & Associates for working so hard on this webinar to make it available to gun owners, NRA, CRPA members across the state of California. As Matt mentioned, I'm Dan Reed. I'm Western Regional Director with National Rifle Association and Institute for Legislative Action. I'm your lobbyist here in California, and I work very closely with CRPA as well as other groups fighting for your rights up here in California. We've got a couple of pictures up here just to put a face with the name. There's a picture with Sam Paredes of Gun Owners, Shasta County Sheriff Tom Basenko, CRPA Legislative Advocate Roy Griffith, and myself after a hearing earlier this year, as well as a picture of Roy and myself at the CRPA pheasant hunt that was held in Northern California earlier this fall. So in California, CRPA and NRA work really closely together. CRPA is the only state affiliate of NRA in California. They are independently operated by their own board of directors. And we work together as a team fighting for your rights here in California and up in Sacramento at the Capitol, as well as working on local issues as well as regulatory issues, et cetera. And this partnership helps us be more effective in advocating for gun owners across the state of California. You can see this chart shows that relationship. This next slide here has some of the various projects that we do work on. I mentioned legislative advocacy in Sacramento. That's the NRA ILA alerts as well as CRPA legislative alerts that tell you about various bills that are moving through the legislature and what sort of actions you can take to help us be more effective in our grassroots and trying to stop bad stuff from happening and get good things across the finish line. We also partner with our litigation efforts, obviously very important here in California. Matt, who is presenting, is one of the key attorneys at Michelle & Associates who works on that litigation. Local advocacy and ordinance projects, monitoring and promoting. This is important in California. We have various issues pop up across the state. In fact, just today, there was a hearing down in Orange County, and there's been some efforts to ban gun shows across the state. And we had good news out of Orange County today where they have opted to renew the gun show contracts for the remainder of the year. There was a really strong showing from gun advocates at that meeting. And so thank you to all who attended to help keep those gun shows alive. Hunting and regulations and petitions, this is something where we're active at the Game Commission. We've had some success there, including allowing you to carry while bow hunting. That does not apply to deer. We have an alert out on that, so be sure to check that out. The DOJ watchdog program for the Bureau of Firearms, as we are doing here today, we're going over regulations for the ghost gun bill that was passed 2 years ago. The regulatory efforts from DOJ can make the law a little bit different than it may appear in the statutes, and so that's why we do host these webinars. And so we pay close attention to those, submitting comment letters, showing up at public comments, as well as we have some litigation that has gone on with the regulatory aspect of this. There are shooting programs, training programs, those speak for themselves, as well as our state and local election and campaign efforts. We just had the primary earlier this month, and we have a very important election coming up in November, so stay tuned to your alerts on those, as well as our range and FFL assistance program where we work with ranges and FFLs on various issues from environmental concerns, et cetera. So with that, I will turn it back over to Matt. Thank you so much for joining, and take it away, Matt.
Real quick, Dan, did you want to talk about the Supreme Court Justice seat opening?
Sure. Many of you probably have heard that Supreme Court Justice Anthony Kennedy announced his retirement just yesterday. This is huge news, obviously. President Trump had the opportunity to fill a seat recently with Justice Gorsuch, and so now this opens up another opportunity for a justice. Obviously, the Supreme Court is incredibly important, and we have had some good decisions via Heller and McDonald, and there's a whole line of cases that are waiting to go up that impact your right to keep and bear arms. So stay tuned on that.
All right. Thank you very much, Dan. Okay, guys, so today, as most of you are here know, today's objective, we're going to hold a short discussion of Assembly Bill 857, specifically what the requirements are in the Penal Code, but really the focus of today is sort of an in-depth analysis of DOJ's regulations for the implementation of AB 857, specifically as they're referred to firearms identifying information and the unique serial number application process for self-manufactured or self-assembled firearms. Generally, as with all of these webinars, of course, this is provided for education and or informational purposes only. It does not establish an attorney-client relationship. We can't make any guarantee or promise as to the accuracy or completeness of the information in this webinar, particularly because a lot of this stuff is subject to change, so depending on when you're actually reviewing this webinar, as we've mentioned, this will be recorded. This will be available on CRPA's website. Some of this stuff does change, and of course DOJ, in regards to how they implement this stuff, can differ slightly depending on what we actually see in practice. So just be aware of that. If you have any questions or concerns after the webinar, or if there's anything else that you feel isn't addressed, of course we're trying to address everything that we can conceivably think of in this webinar. But nevertheless, if you do have questions, please feel free to send an email to contact@crpa.org, and we'll do the best we can to answer your questions. One other thing that I wanted to make sure that everyone is here is aware of is there is a pending deadline to register firearms now classified as assault weapons this Saturday at midnight. As of now, as of today, during this broadcast, you have less than 60 hours to register any firearms that you want to register as assault weapons. We have done webinars in the past on both the actual registration process as well as the other options that are available to you, specifically making your firearm either, quote, California compliant or, quote, featureless. So if you guys are considering registering, I encourage you, I would suggest probably even not staying for this webinar. You guys should really be focusing on trying to register your firearms as assault weapons, because as I understand it, the website at this time is currently having a significant load on it as a result of people trying to register, and so it's been having some issues. So if you need to register, please get on the website and start the application process and get it submitted, especially before midnight on Saturday. That's the last time you will be able to register your firearm as an assault weapon. We are, of course, also looking for plaintiffs. We do file lawsuits regularly on behalf of both the National Rifle Association and the California Rifle and Pistol Association. We can always use people to help out with that. If you're interested in doing so, I encourage you, please send an email to potentialplaintiffs@michellelawyers.com. Just in general, and of course, if you want to help out, please feel free to reach out to both NRA and CRPA. They have a number of opportunities that are available to you, both to get involved locally and elsewhere in your area to sort of help promote and protect the right to keep and bear arms here in California. So with that said, let's sort of get started. The first thing that I want to talk about are the definitions that the Department of Justice has enacted regarding the implementation of AB 857. The reason why I want to talk about the definitions first is that they apply both to the regulations that the Department of Justice has enacted, as well as the Penal Code sections specifically for AB 857. So moving forward here, you'll note that I have these terms. I've got a number of slides here for the definitions. They're found in Section 5507 of the regulations that DOJ has adopted. I have them highlighted here in sort of a bold, light bluish color. That's sort of your cue throughout the presentation. Whenever I have slides up that have specific words that are defined by DOJ in their regulations, I've highlighted those throughout the presentation, so that sort of cues you to go, there's a specific definition for that the Department of Justice has adopted. So if you have a question about that, you know that there's something that you can reference for that. So getting started here, antique firearm. Any firearm not designed or redesigned for using rimfire or conventional centerfire ignition with fixed ammunition and manufactured in or before 1898, including any firearm with a matchlock, flintlock, percussion cap, or similar type of ignition system or replica thereof, whether actually manufactured before or after the year 1898. This also includes any firearm using fixed ammunition manufactured in or before 1898 for which ammunition is no longer manufactured in the United States and is not readily available in the ordinary channels of commercial trade. So there's a lot to that definition, and I know you guys probably have some questions on that. I want you to sort of hold off on that and put that in the back of your mind because there's a point that I'm going to be making about this definition here later. A couple other definitions here. Barrel, the tube, usually metal and cylindrical, through which a projectile or shot or charge is fired. Barrels may have a rifled or smooth bore. And then barrel length, this is kind of important, specifically how you actually measure the barrel length of a firearm. For those of you that haven't done this before, this is done by using sort of like a dowel rod that you insert into the muzzle end of the barrel until it hits the closed bolt face of the firearm. And then what you'll do is you'll mark the end of the dowel rod from where it hits the furthest most point of the barrel or the permanently attached muzzle device. It's important that if you're measuring it with a muzzle device on the barrel, it has to be permanently attached, and there are specific definitions for what is required. Methods include full fusion gas or electric steam seal welding, high temperature soldering, or blind pinning with the pinhead welded over. So just be aware of that. A couple other definitions. The bore is the interior of the firearms barrel excluding the chamber. And then of course Bureau, the Bureau of Firearms of the California Department of Justice. That is specifically the branch of the California Department of Justice that handles all firearm related issues generally. Caliber, this is the nominal diameter of a projectile of a rifled firearm or the diameter between the barrel lands, and then this is measured either in the U.S. typically in inches, Great Britain thousandths of an inch, and then Europe and elsewhere in millimeters. CFARS, that is the California Firearm Application Reporting System. We'll be talking about that a little bit here later today. That is the website in which not only are you required to register assault weapons, as many of you may know, but also that it will be required for you to apply for a DOJ-approved serial number for the firearms that we'll be talking about here later today. Conspicuously, all required markings are placed in such a manner as to be wholly unobstructed from plain view. And then curio and relics, this includes firearms manufactured at least 50 years prior to the current date, but not replicas, firearms certified by the curator of a municipal, state, federal museum, which exhibits firearms to be curios and relics of a museum interest, as well as any other firearms for which derive a substantial part of their monetary value because they are novel, rare, bizarre, or association with some historical figure, period, or event. One thing I want you to note here is the definition for curio and relics specifically is identical to that of the federal definition, which again, like I said, I'll talk about here in a little bit. Department, California Department of Justice, pretty obvious there. Firearms eligibility check, really what they're talking about is a background check pursuant to the Penal Code. Frame, this is the basic unit of a firearm that is a handgun specifically. As you'll see there on the slide later, when you're talking about receiver, that is the basic unit of firearm that is a long gun. And so the Department of Justice has distinguished between those two terms specifically just for the purposes of understanding the definitions. And then, of course, FSC, HSC, Firearm Safety Certificate, Handgun Safety Certificate, legibly marked. This means exclusively Roman letters and numbers. As you can see, examples there, basically pretty straightforward. And then receiver or frame unfinished. This is where it gets a little interesting. Essentially, this is the precursor part to a firearm that is not yet legally a firearm. So what are we talking about there? So these pictures that you have here are pulled directly from the ATF's website. Generally, when a firearm, when a part, I should say, becomes a firearm is really within the purview of the ATF. And so with regards to 80% receivers, which is what we are commonly talking about here, like those for AR-15 style firearms, the ATF has really sort of specified when that 80% receiver becomes a firearm within the eyes of the law. And so just sort of generally speaking, whenever the fire control assembly pocket where you insert the trigger into the AR-15 receiver is drilled out even partially, like on the picture there of the black 80% receiver there, at that point it becomes a firearm. And so the DOJ there on the side, that's the quote that they have in their definition with regards to unfinished frames or receivers. Essentially they're suggesting that as more finishing work is completed to the precursor part, gradually becomes a firearm. And then, for example, just having the shape of an AR-15 low receiver, but some are solid metal, some have had work done, and for example, the magazine well has been machined open. And so the magazine well is not necessarily the part that determines when it becomes a firearm. It's really that fire control assembly where the trigger is actually inserted, at least on AR-15 style firearms. So just to give you an idea of what it is we're talking about here with regards to precursor parts. And then the last couple set of definitions here, rifle, pretty straightforward definition, a weapon designed or redesigned, made or remade, and intended to be fired from a shoulder, and designed or redesigned and made or remade to use the energy of the explosive in a fixed cartridge to fire a single projectile through a rifle bore for each single pull of the trigger. That definition is essentially word for word in the Penal Code for the definition of rifle, not really much different there. And then lastly, self-assembled or self-manufactured. Specifically, this is a firearm fabricated or constructed, including firearm constructed using a 3D printer or any other technology by a person or a firearm, the component parts of which were fit together by a person to construct the firearm, but does not include a firearm assembled or manufactured by a licensed manufacturer, which we'll talk about in a little bit, or a firearm with a serialized receiver pursuant to the from a California gun store. So if you bought just a lower receiver, for example, from a gun store in California that has a serial number on it already, that's not what we're talking about here specifically. So with that said, let's look at those are all the definitions for the regulations that the DOJ has enacted. So let's look first at the Penal Code provisions that were enacted by the legislature, which do include some of those terms in there. Generally speaking, really you should be aware that there are two important dates that you want to understand what the requirements of this new law are. So essentially beginning July 1st, 2018, and then after that date, so essentially starting on Sunday, prior to manufacturing or assembling a firearm, individuals must first apply to the DOJ for a serial number and engrave that DOJ-approved serial number within 10 days of manufacturing it. After doing so, you must then also notify DOJ in a manner prescribed by the regulations that they've adopted, which we'll talk about here in a little bit as well. And then January 1st, 2019, that's another important date to remember because essentially for all firearms lacking serial numbers that you already own prior to that July 1st implementation of this law, there are plenty of people out there that have built their firearms prior to the implementation of this law. Absent certain exceptions, which I'll talk about, individuals must obtain and engrave a DOJ-approved serial number in the same fashion as you would if you were manufacturing it after July 1st, 2018. But you must do so before January 1st, 2019. So essentially that's the difference. So starting July 1st, if you're going to be manufacturing a gun from an 80% receiver, you have to go through this DOJ serial number process first. And then for those of you that already own guns, lacking DOJ-approved serial numbers prior to July 1st, you will essentially have to go through this same process, but you have until January 1st to complete that process. But just be aware, like I said, there are certain exceptions here. So a couple prohibitions and penalties that you should also be aware of. Generally, as applied to the Penal Code does have a specific definition for the term manufacturing and assembling. This is not something that's in DOJ's regulations, but this is actually found in the Penal Code itself. Essentially, they've defined this as fabricating or constructing a firearm or fitting together the component parts of a firearm. And then with the exceptions of transfers to law enforcement for the purposes of destruction, the sale or transfer of any firearm manufactured or assembled pursuant to these requirements is strictly prohibited under California law. That is in the penal code itself. So if you have one of these guns that you've built either from an 80% receiver prior to July 1st or afterwards, you cannot sell or transfer it to anyone in the state of California according to this penal code provision. You also cannot knowingly allow, facilitate, aid, or abet the manufacture or assembly of a firearm by a prohibited person, obviously. And then what you all should understand is that violations of these requirements are considered misdemeanors. For rifles specifically, if a violation is punishable up to 6 months imprisonment and or a fine of up to $1,000. Handguns, it's essentially the same with the one exception that instead of 6 months, it's up to a year imprisonment and then the $1,000 fine. But most importantly, each firearm constitutes a distinct and separate offense. So if you have 10 firearms, potentially 10 years in prison, $10,000 fine. Just make sure you all understand that as far as what the actual restrictions are and what penalties are associated with this. The one thing I want to point out too is that there is technically a restriction under federal law for the sale or transfer of any firearm manufactured from an 80% receiver. In general, there are no federal restrictions in place for making firearms for personal use. So there's nothing under federal law that prohibits you specifically from making a firearm from an 80% receiver, as long as the firearm that you're manufacturing, of course, doesn't otherwise violate the Gun Control Act or the National Firearms Act. For example, you can't make a machine gun or a sharp-barreled rifle or something like that. But if it's just a standard rifle, AR-15 style rifle, nothing under federal law specifically prohibits you from doing that. However, the ATF has clarified that anyone manufacturing firearms who also wish to sell or transfer such firearms must obtain a federal manufacturing license and must also engrave each firearm with appropriate identifying information as required under federal law. So in other words, it's generally illegal under federal law to sell or transfer a firearm manufactured from an 80% receiver unless the firearm was manufactured by a licensed manufacturer who also engraved the firearm appropriately. So just know that there is that federal restriction too, that if you're thinking about selling or transferring a firearm built from an 80% receiver, while the California law was recently amended to clarify that, ATF has held since 2010, and they clarified it later in 2015, that the transfer of these firearms is prohibited unless that firearm, like I said, was manufactured by a licensed manufacturer, because at that point you're considered to be in the business of manufacturing firearms. And if you didn't have a license when trying to sell that firearm, that's problematic under federal law. Polymer plastic firearms, there is this additional requirement that was enacted under AB 857. Essentially, for firearms manufactured or assembled using polymer plastic, you need to have 3.7 ounces of stainless steel embedded into the plastic upon fabrication or construction of the firearm. This is also where the DOJ approved serial number must be engraved in a manner that satisfies federal requirements for engraving a firearm, and that's under the California Penal Code sections that were enacted pursuant to AB 857. The one thing that I want everyone to understand is that this Penal Code section only lists this requirement for firearms manufactured or assembled after July 1st, 2018, meaning it's not specifically required for firearms lacking serial numbers that you previously owned prior to July 1st, 2018. So for all of you that have 80% receivers that are made from polymer plastic firearms, if you want to complete those firearms, you need to do so prior to July 1st. Otherwise, if you are going to be going through this serialization process from DOJ, they will not approve a serial number for a firearm made only from polymer plastic that doesn't have that 3.7 ounces of stainless steel. And frankly, I have not yet seen a polymer plastic 80% receiver built using that amount of steel to satisfy this requirement, so I'm unaware of anyone that is actually doing that yet. So just be aware that that's the case. To sort of clarify this, the Department of Justice, in their own words, when we submitted public comments on this issue, they responded to those comments and specifically stated that they had revised their regulations to clarify, again, that this only applies to firearms manufactured or assembled after July 1st, 2018, in conformity with the requirements of the statute. So the Department of Justice themselves, don't take my word for this, has also stated, at least publicly, that this requirement only applies to firearms manufactured after July 1st, 2018. So essentially Sunday. So what firearms are exempt from these requirements? And so according to the Penal Code, they list 5 specific examples of when a firearm is not required to be serialized in accordance with these provisions. First, any firearm that was already equipped with the serial number assigned by DOJ or in accordance with sections 921 through 931 of Title 18 of the United States Code and the applicable regulations. So essentially, if DOJ, for whatever reason, assigned a serial number to the gun or some other identification mark, which is then DOJ is made aware of at some point, those firearms should not be included as far as ones that need to actually go through this process. Also, firearms made or assembled prior to December 16, 1968 that are not handguns. I'm going to talk about that here in a little bit. Firearms voluntarily registered with the DOJ that have a distinguishing number or mark of identification. But here's the key, guys. The registration must also have been accepted by the DOJ, meaning that essentially the way the firearm registry works here in California is there is a database called the Automated Firearm System. Whenever you have a firearm that's registered to you, it shows up in the AFS system. And so if you have a firearm with a serial number, even if it was one that you applied yourself, that's not listed in AFS, that means it's not subject to this exception. In order for it to be exempt from the requirements of AB 857, it has to specifically be listed in that registry of firearms that's maintained by the California Department of Justice. And I'll clarify that here again in a little bit as well. Next, firearms with serial numbers assigned to them pursuant to sections 5801 to 5872 of Title 26 of the United States Code and applicable regulations. And then lastly, curios, relics, or antique firearms as defined in the Code of Federal Regulations. So, a couple things I want to talk about. The federal definition for curios and relics is not found in the Code of Federal Regulations that is cited to specifically in the Penal Code section that was adopted by the legislature. It's only antique firearms are specifically defined there, but even then, this definition only applies to machine guns, destructive devices, and certain other firearms. Curios and relics specifically are defined in section 478.11 as the following: firearms manufactured at least 50 years ago, firearms certified by the curator of a municipal, state, or federal museum, and then firearms deriving a substantial part of their value because they are novel, rare, bizarre, etc. As I mentioned before, this federal definition is substantively identical to the definition that the DOJ has adopted in its regulations. And then federal definitions for antique firearms. So as I mentioned, the definitions that's specifically cited in the Penal Code is specifically for machine guns, destructive devices, or certain other firearms. That's what's actually used as the definition for antique firearms in AB 857. There is another definition found in the Code of Federal Regulations in a different section, which is actually the more common definition, which applies to just generally firearms in general, not specifically machine guns, destructive devices, and certain other firearms. And you can see there their definitions are different. They're slightly different as far as how they're determined to be antique firearms. But I want you to sort of forget about this because it's kind of a superfluous exception. And the reason for that is that if a firearm is manufactured on or before 1898, regardless of the action type or ammunition it uses, regardless if it satisfies this antique firearm definition, it's a curio and relic at that point. And so this is because such firearms are at least 50 years old. And so because it's a curio and relic, it's exempt from the requirements of AB 857. So I'm not certain why there's a limited exception for long guns as well for firearms manufactured prior to December 16, 1968. because, again, such firearms satisfy the definition of curio and relic because, they're, like I said, they're at least 50 years old by the time the registration requirement becomes effective, which is effectively January 1st, 2019. If it was manufactured on December 16th, 1968, it's just a little bit more than 50 years old. So at that point, it's a curio and relic. Don't just take my word for it, though. This is what the DOJ has said in response to public comments on this issue. It says firearms without a serial number made by a company before the Gun Control Act would not be subject to these regulations. Such firearms meet the definition of a curio relic because they were manufactured at least 50 years prior to January 1st, 2019. That is word for word what DOJ has said in response to public comments on the issue. The Department's definition for antique firearm is directly taken from the section that was referenced in the Penal Code. But they sort of note, for example, that the curio and relic definition is not found in that section. And so when the Department of Justice enacted its definition for the term curio and relic, it specifically referred to that federal definition that I referenced that's in 478.11. So that's essentially the DOJ themselves stating that, they understand at least that the definitions that the legislator pointed to, it's not necessarily correct in regards to the definition for curio and relic, and so the DOJ has clarified that, at least in the regulations that they've enacted. So application requirements, specifically if you're seeking a DOJ-approved serial number, this is what you must do. You must first undergo a firearms eligibility check. You must also present a valid California driver's license or ID. You must be of the minimum required age depending on the gun that you're trying to register, 18-year-old for long gun, 21-year-old for handguns. You must also provide a description of the firearm in a manner prescribed by DOJ in the regulations, which we'll talk about here in a little bit. And you must also possess a valid firearm safety certificate or handgun safety certificate. Those are the requirements that are specifically listed under the Penal Code. So with all that said, that's sort of a quick review of AB 857. Let's talk about the specifically the regulations that DOJ has enacted implementing this section. So these are if you're interested in looking at these regulations in more detail, they're found in sections 5505 through 5522 of Title 11 of the California Code of Regulations. Specifically, they're referred to as identifying information in the unique serial number application process for self-manufactured or self-assembled firearms. So first thing I want to look at, scope of the regulations, their exceptions, and persons affected. So the first thing is the scope. What do these regulations really apply to? They apply to an individual who owns a self-manufactured or self-assembled firearm before July 1st, 2018 that is not recorded with DOJ, as I talked about, and shall also apply to an individual who intends to manufacture or assemble a firearm on or after July 1st, 2018. The regulations also apply to self-manufactured or self-assembled firearms made from any material, including wood, metal, or plastic, and made through any process, including those produced by 3D printers, unless the firearm is of a type specifically listed in the Penal Code section 29181 of those firearms that are exempted from these requirements. There are also firearms specifically that the Department of Justice has stated that they will not register regardless. These include generally prohibited firearms specifically listed in Penal Code section 16590, things like cane guns, short-barreled rifles, shotguns, unconventional pistols, wallet guns, zip guns, etc. These are specifically prohibited under California law, so obviously manufacturing them yourself is a problem under any circumstance. They will not specifically register assault weapons, machine guns, 50 BMG rifles, destructive devices, for example, firearms with a caliber greater than .6, and short-barreled rifles or short-barreled shotguns. So DOJ's own words regarding this, this section implements the Penal Code by stating that the Department will not provide serial numbers for certain kinds of firearms that an individual may manufacture or assemble if possession of those firearms is otherwise illegal under existing laws. It also goes to clarify that these regulations, of course, come into effect on July 1st, 2018, after the deadline to register an assault weapon has expired. So for that reason, these regulations do not apply to the registration of assault weapons for those firearms manufactured from 80% receivers. The assault weapon regulations themselves have specific requirements for firearms that were manufactured from 80% receivers. that you have to refer to instead of these regulations. These are not the regulations to refer to in that regard, so just be aware of that. So let's look at the exempt firearms. So I have sort of the list here of the firearms that are exempt according to DOJ's regulations, and I want to compare them to the Penal Code exceptions that we talked about specifically. So obviously under the first one, Penal Code exemption states that firearms already equipped with serial numbers assigned by DOJ or in accordance with the United States Code and applicable regulations. DOJ's regulation, however, specifically uses the phrase self-manufactured or self-assembled firearm in lieu of the term firearm by itself. So what this does is this effectively narrows that exception a bit, but to be honest, I'm not quite certain how. I haven't necessarily seen what I think is a good example of how this exemption has been narrowed. If any of you can think of one, by all means, please let me know, but for the time being at least, it's generally treated the same unless there's a very specific exemption, which for some reason I haven't been able to determine at this time. Second one, firearms made or assembled prior to December 16, 1968 that are not handguns. The DOJ regulation, essentially there's no substantive difference with their regulation with the exception of stating that as long as the firearm is not a handgun. But again, as we talked about it, even though the regulations and the Penal Code say this, it's a curio and relic at that point. So I don't see why that's sort of important at this stage. Exempt firearms continued. So number 3, firearms voluntarily registered with DOJ that have a distinguishing number or mark of identification, but the registration must also have been accepted by DOJ. The DOJ's regulations, essentially there's no substantive difference, but they do clarify that the distinguishing number or mark is typically one created by the individual who made the firearm and not one issued by DOJ. So that's sort of the distinction there. But again, substantively speaking, not really much of a difference there. The next one, firearms with serial numbers assigned to them pursuant to Section 5801 to 5872 of Title 26 of the United States Code. Again, there's no substantive difference here. However, it clarifies that any firearm with a serial number issued by an FFL does not also require a DOJ-approved serial number. So again, if the gun already has a serial number assigned to it by a manufacturer, it's not a gun that you will have to register. And so I just want to make sure that you guys understand that as far as, I should say, you won't have to register pursuant to these requirements. So you're not going to have to get a DOJ-approved serial number as long as the serial number that was already on the gun was issued by a federal firearm licensee. And then the last one, curios, relics, or antique firearms as defined in Section 479.11 of Title 27. Again, this is essentially substantively the same. The only difference is DOJ has clarified this a bit in the definitions that they've enacted. So essentially the definitions for curio, relic, or antique firearm as specifically defined by DOJ is what the DOJ regulations have stated. Persons affected. So the regulations apply to individuals who own a self-manufactured or self-assembled firearm originally made from an unfinished receiver or frame as of July 1st, 2018, and those who intend to manufacture or assemble a firearm from an unfinished receiver or frame on or after July 1st, 2018. Individuals who own these firearms, self-manufactured or self-assembled firearms originally made from an unfinished frame or receiver as of July 1st, 2018 that have not yet been recorded with DOJ must apply for a DOJ-approved serial number by submitting an electronic application before January 1st, 2019. So again, they're sort of reiterating that point. And then as of July 1st, 2018, no individual shall manufacture or assemble a firearm from an unfinished receiver or frame unless the individual applies to DOJ for a unique serial number prior to the manufacture. Okay. And then DOJ's own words regarding the registration of firearms owned prior to July 1st, 2018. The system will automatically stop accepting applications at 12 a.m. midnight as soon as the date changes to January 1st, 2019. So the purpose of mentioning this is that the application is available essentially until 11:59 p.m. on December 31st, 2018 for those firearms that were owned prior to July 1st, 2018. So just be aware that that's the case, that if you're going to be applying for a serial number for a firearm that you owned prior to that date, just know that the application for that is different and it will no longer be available after essentially beginning 12 a.m. on January 1st, 2019. So moving on to sort of the next section, the CFARS reporting of self-manufactured or self-assembled firearms. Specifically, these are sections 5511 through 5517 of the regulations. There is an online reporting requirement. Essentially, all applications for DOJ-approved serial numbers must be filed electronically using the Department's CFARS system. I've given you the link there. Again, this is the same website for the registration of assault weapons. For those of you that have gone through that process already, you should at least be somewhat familiar with it. The application itself will be listed on that website as, quote, unique serial number application. So that's the actual link that's going to pop up there starting July 1st for these types of firearms. Applications requesting a unique serial number to record ownership of a self-manufactured or self-assembled firearm that was built prior to July 1st, again, will only be available until 11/59 of December 31st, 2018. And then to be processed, that application must be paid in full and submitted online before January 1st, 2019. So this kind of indicates that you have to submit that application prior to then and pay for it in full in order for DOJ to process it. So for example, if you submit the application on December 30th, that at least indicates that DOJ will continue to process it as long as it was submitted and paid in full prior to January 1st, 2019. Just to give you guys an example, for those of you that haven't seen this already, this is what the CFARS website looks like from the home page. There is a username and password that you have to log in. You'll essentially have to create an account here, which I'll go into a bit. There is also, the Department of Justice has recently launched a unique serial number application web page, which provides some additional information on this process. And so I've given you guys the link there. So if you haven't seen that yet, this is now up on DOJ's website for you guys to take a look at. The one thing that sort of caught me off guard with this, if you go look through that actual web page, there's a section there that talks about the required applications and specifically the actual application process. And according to this web page, as I read it, there's essentially a separate paper application that you guys are going to have to submit in addition to this for the eligibility check portion. And sure enough, according to that, the form number that they gave me, I did a search for it. I was actually able to pull this form up. If you guys want to search for it, you can Google BOF 120 is the number of the form. There is a specific request for unique serial number application, personal firearms eligibility check application that appears you guys are going to have to submit in addition to the online system. And so that's something that has not yet been clarified, at least in the regulations. And in fact, I think both the penal code and regulations sort of indicate that there shouldn't be a paper application, but nevertheless, it appears that that's the case. So just be aware of that. If I had to guess, the reason why is because the personal firearms eligibility check application requires you to submit a thumbprint. And so you'll notice if you guys pull up this application, there's a section there where you have to put on your thumbprint in order to actually submit that. And so I think that's part of the reason why they're doing this. But nevertheless, it's not something that's specifically talked about either in the regulations or the penal code. So just be aware that if you are going to be submitting these types of applications, according to their website, at least right now, you are going to have to fill out that form in addition to submitting an application through the CFARS website. So going on to that, the account creation process, there are a few things that you're going to have to do here before creating an account if you haven't done this already. You're going to have to agree to sort of the following requirements: that there's a non-liability clause, an authorization, and then the fees and the true and accurate information section. Essentially, you have to agree to all of this in order to create an account. So just be aware that that's what you're going to have to do in order to get that account up. And then, of course, there's a privacy notice. Specifically, applicants for DOJ-approved serial numbers must agree to the Department's privacy notice, which states the following, and includes collection and use of personal information, providing personal information, access to your information, and possible disclosure. A couple things that I wanted to talk about this specifically, starting off with the non-liability clause. So just generally know that under the California Constitution, every individual is entitled to certain inalienable rights, including the right to privacy. And then, of course, with the government's ever-increasing demand for personal information like this, believe it or not, the California legislature enacted what's called the Information Practices Act to sort of bolster those protections. And essentially, among other provisions, that act, the IPA, prohibits DOJ from disclosing any personal information in a manner that would link that information to the individual to whom it pertains, absent limited exceptions. This clause, there was an identical clause that was challenged in the case in Villanueva v. Becerra regarding the bullet button assault weapon regulations. In response to that challenge, the DOJ attorney in that case clarified that the non-liability clause does not conflict with the California Constitution or the IPA because that clause specifically includes language that says that applies except as may be required by law. And then also going further than that, in regards to this particular issue, the DOJ has stated in regards to public comments that we raised on the same issue here, that both the IPA, the Public Records Act, the Government Code, and other laws pertaining to privacy still apply in this case. And so the Department does not disclose personal data without the consent of an applicant unless authorized by law, and may use security technologies to protect an applicant's personal information against loss, unauthorized access, and illegal use of a disclosure. Access to personal information is limited to the department staff who work on requiring such access, so those are essentially processing the application. So just understand that according to DOJ at least, this particular regulation is not a waiver of your privacy rights. I want everyone to make sure they understand that. It's just a required notice that's required under California law. It informs you that the applicant, the department, is collecting personal information and how that personal information will be used by the department as authorized by law. So I want to make sure everyone understands that. So there is a required background check associated with this, as I mentioned earlier. Essentially, before being issued a DOJ-approved serial number, you must provide certain identifying information to demonstrate that you are not prohibited under state and or federal law from possessing a firearm. In order to process this, this is the information that you must provide, essentially your full name, residential street address, email address, telephone number, date of birth, gender, military identification number if it's applicable, your California driver's license or ID number, U.S. citizenship status, place of birth, country of citizenship, and alien registration number if applicable. And then again, of course, you must also be of the minimum required age depending on the firearm that you're applying for a serial number for. And then you must also include a description of the firearm that includes the date of manufacture or assembly will be complete, the type of firearm, the caliber, color, barrel length, type of material used, whether it's aluminum, steel, polymer, plastic, or otherwise, and then whether it's a frame or receiver only, all identification marks, and the firearm city and state of origin. And then finally, your FSC and or HSC number. Those are specifically the requirements that you must satisfy in order to submit the background check for this process. So just be aware of that. A little bit more information here regarding some clarification from DOJ in response to public comments that if the firearm is a frame or receiver, the electronic application will automatically account for that. And so you will not need to include the barrel length in that application. And then also, it will automatically populate certain fields with regards to the caliber. And just note that that is an option that is accepted by DOJ and its system that they've implemented. So if you're creating an application for a frame or receiver only, just be aware that that's how the process appears that it will work. Furthermore, the unique serial number application on the CFARS website provides an option for the applicant to select multi-caliber on the drop-down menu. And then just note, of course, the department requires a date of manufacture to distinguish between a self-manufactured or self-assembled firearm that is an individual intends to build and a firearm that an individual has already manufactured and assembled that does not bear a serial number assigned to it. So essentially what they're trying to get at there is the reason why they're asking for the date of manufacture assembly is they want to be able to distinguish between guns that were owned prior to July 1st and those that were manufactured after July 1st. There are also fees required for the application process. Just generally, if it's a single firearm, it's a $35 fee, $20 of which is for the firearms eligibility check as conducted by the department. And then the additional $15 is for the issuance of one unique serial number for one firearm. So if you have additional requests for, if you're applying for multiple firearms, you can do so. There is no limit on the number of firearms that you can request serial numbers for in a single application. So if you have multiple firearms that you're intending to register according to this process, I encourage you to do so, because you at least will only have to pay the $20 eligibility fee once. Otherwise, additional applications will require that eligibility check every single time. But just note, for additional firearms, it's $15 per firearm. You must pay the fee online by debit or credit card at the time the application is submitted. And then once the eligibility check is complete, an electronic copy of the original determination letter will be sent to you on the CFARS website. And so you'll have access to the eligibility check response for a limited time on the CFARS website, at least according to DOJ's regulations. You will not get a physical copy, so just be aware of that. So if you want to know whether or not you pass the background check, you will not be mailed specifically a physical copy. It will only be available on the CFARS website. So once you get that, I encourage you to print and save a copy for your records. There's also one serial number issued per firearm, and they will assign each self-manufactured or self-assembled firearm its own unique serial number so that each firearm is distinguishable from any other self-manufactured or self-assembled firearm. If you're requesting multiple serial numbers because your application is requesting serial numbers from more than one firearm, each unique serial number issued will differ and be distinct, and the DOJ will inform you which serial number is specific to which firearm according to the applications that you submitted. Prior to issuing a serial number, DOJ will, of course, conduct the eligibility check. So they're going to do that first before they actually give you a serial number. Both state and federal records will be examined. Once the DOJ processes the application, it will notify you either that you pass the background check, essentially stating that you're eligible and that you'll be assigned a unique serial number, or in the other case, revealed that you're ineligible to own or possess firearms, and or it could not generate a disposition. So essentially, there's two options here. Either it's going to say you passed, or you didn't pass, and or DOJ couldn't determine whether or not you're prohibited from owning or possessing firearms. If you're ineligible, a unique serial number, of course, will not be issued, and you will receive a denial notification through the CFARS website, and it will explain the reasons for the denial, how to get a copy of the record causing the denial, and any instructions on how to dispute or correct the record. There's a 15-day processing period. Essentially, the department will grant or deny the applicant's request for a unique serial number within 15 calendar days after the application has been paid for and submitted to CFARS to commence the firearms eligibility check. So essentially, expect to wait at most up to 15 days for determination one way or another once you submit the eligibility check. This is important. This is one thing that I want to make sure that all of you understand, that according to DOJ, they've responded to public comments that there will be no situation where an application will be neither approved nor denied. So they're not going to have sort of like an undetermined status like they do for typical DROS transactions at dealers. And so they've clarified that the department will deny a unique serial number application if no disposition can be granted based off of your criminal history. So essentially, if you're the type of person that's getting an undetermined status from DOJ after you've attempted to purchase firearms here in California, submitting a application for a DOJ-approved serial number, they will deny your application for that same reason. So I encourage you that if you're unsure or you think you might have this issue, you should at least submit a personal firearms eligibility check prior to submitting an application for a DOJ-approved serial number to sort of get an idea whether or not you think that could potentially be an issue. That way you'll at least have some idea. Outside of that, by all means, please feel free to contact us. Let us know if you have any issues like this. It is possible that many people that I've seen have had issues in their record that basically causes DOJ to have undetermined statuses, and hopefully that's something that can be corrected, ideally before you actually try and apply for a DOJ-approved serial number. So just be aware of that, because like I said, they will deny your application if they can't come to the determination in 15 days. So the next section, talking about engraving the unique serial numbers, uploading digital images, and modification of the firearm. Specifically, this is all discussed in sections 5518 through 5522 of Title 11 of the California Code of Regulations. There are some deadlines that you have to engrave a firearm. So for self-manufactured or self-assembled firearms owned prior to July 1st, 2018, you must engrave, cast, stamp, or permanently place a conspicuous location on the receiver or frame of the firearm the unique serial number within 10 calendar days after receiving the serial number from DOJ. So the date of receipt will be the date on the email containing the electronic notice that tells you to log into CFARS. So if you guys are having trouble with regarding to your email, not getting emails from DOJ, make sure your spam filter isn't blocking them or anything like that, to make sure that you receive that notification, because that's essentially what starts the countdown from the time in which you have to apply that serial number according to DOJ. And then afterwards, you must then upload the digital images of the firearm within the 10-day deadline. Failure to engrave or upload images within this deadline will result in the unique serial number becoming invalid and will require essentially resubmission of an application. And just note, of course, if this is for firearms manufactured or assembled prior to July 1st, 2018, you still have that January 1st, 2019 deadline to worry about. So if you fail to do this, for an application that you submitted on December 31st, and that application is subsequently denied, or the serial number is invalid because you failed to apply that serial number within 10 days of receipt, there's going to be no way for you to complete that application process after January 1st, 2019. So just be aware of that. And then for firearms manufactured or assembled after July 1st, 2018, there are two deadlines that you should be aware of. So within 30 days of receipt of a unique serial number, you must engrave, cast, stamp, or impress, or permanently place the serial number in a conspicuous location on the receiver or frame of the firearm. The date of receipt, again, is that email that we talked about that you will receive notice of through CFARS. And then within 10 days of manufacturing or assembling that firearm, you must engrave, cast, stamp, or impress, or permanently place the serial number in a conspicuous location on the receiver or frame of the firearm. In other words, if you wait more than 20 days to manufacture or assemble the firearm, you will have that many days less to engrave the firearm with the unique serial number despite the 10-day window, as the entire process must be completed within 30 days. So I want to make sure everyone understands that. I know that can be a little bit confusing, but just know essentially the key thing to remember here then is that the whole process must be completed within 30 days regardless. If you fail to upload digital images or apply the unique serial number before the 30-day period expires, you have until the end of the 30th day to provide the correct information to DOJ. So just be aware of that as well. For polymer plastic firearms, again, firearms manufactured or assembled from polymer plastics on or after July 1st, 2018, they of course must contain 3.7 ounces of stainless steel, which must be embedded within the plastic receiver or frame upon the firearms manufacturer assembly. So as I stated before, I have not yet seen any particular company or business that is manufacturing 80% receivers from polymer plastics that has these this required amount of metal inserted into them. It could of course happen, but just note that essentially this forecloses on an entirely polymer plastic firearm in the state of California manufactured after July 1st, 2018. So just be aware of that. Engraving procedures. Upon the receipt of the DOJ-approved serial number, you may do one of the following to actually have the frame or receiver engraved. You can contact a Type 7 FFL, specifically to have it applied in a manner consistent with state and federal law. Just be aware, however, that they're under no obligation whatsoever to perform this work. And so it might be worthwhile calling them in advance or checking with them to see if they're willing to perform this service for you and sort of arrange that before showing up at their door and then turning you away because they don't want to do it. So just be aware of that. Alternatively, you can seek assistance from an unlicensed individual or business. For example, you can have someone that just does engraving but isn't necessarily an FFL. If you are going to utilize this type of business, however, again, they're not FFLs, so what that means is that you can never leave the firearm unattended with them. So if you want to do it this way, you will have to essentially stay with them while they engrave the frame or receiver before actually leaving and then taking that receiver with you. It's not something that you can leave with them. Lastly, of course, you can personally apply your own unique serial number that was issued by DOJ if you so choose. Just, of course, be aware that you are subject to the requirements for engraving, and which I think we'll talk about here specifically. Regardless of the manner selected, you must legibly and uniquely mark and identify each self-manufactured or self-assembled firearm as follows. You must engrave, cast, stamp, impress, or otherwise permanently place in a conspicuous location on the receiver frame the unique serial number in a manner that is not susceptible of being readily obliterated, altered, or removed, and you shall not duplicate any serial number placed by the unlicensed manufacturer on any other firearm, obviously. Additional information including the model, if applicable, the caliber/gauge, the manufacturer's first and last name, in this case yours, if you're the person manufacturing it, and the city or state or recognized abbreviation thereof must also be engraved, cast, stamped, or otherwise conspicuously placed on the frame, receiver, or barrel. Markings must be a minimum depth of 0.003 inches and in print no smaller than 1/16 of an inch, measured from the flat surface of the metal and not the peaks or ridges and latitude ends of the character impressions or bottoms or the bases. And so essentially they're giving you specifics as far as the required depth and the required size of the actual text there. So just be aware of that as well if you're, for example, going to be engraving it yourself. There are also digital images that are required for this. So essentially upon completion of the engraving requirements, applicants must upload a total of 4 clear digital images of the firearm depicting the firearm and its newly engraved serial number as follows. You must have 1 image of a close-up of the unique serial number and additional information located on the receiver/frame or of the firearm. You must have 1 image of the entire firearm encompassing the following. Specifically for long guns from the end of the barrel to the end of the stock, handguns from the point furthest from the end of the barrel to the opposite end of the handgun, or if it's a receiver or frame only, just essentially the entire firearm. It's pretty simple, pretty straightforward there, I think. And then you must have 1 image each of both the left and right sides of the receiver/frame. So again, I'm not entirely certain yet here because with regard to that last requirement, if one of those images will also satisfy the entire firearm image requirement if, for example, it's just a frame or receiver. So I would suggest, at least for the time being, unless DOJ clarifies otherwise, that you upload 4 images regardless if 2 of them, for example, might still be the same with regards to a frame or receiver only. Modification of the firearm. Applicants may make changes to the configuration of the firearm within 30 days following the date the DOJ issued a unique serial number. So if you want to make any changes, you may do so within 30 days of receiving the serial number. Any changes, of course, must be recorded in the application that was submitted in the CFARS website, and the uploaded digital images must reflect the final version of the firearm. Now, when this regulation was enacted, there was some question with regards to whether or not you could change the firearm after the serial number process has been completed. And at least for the time being, it seems, according to DOJ, in responses to public comments, they've stated that the regulations do not address the modifications after the unique serial number application process is complete. Just be aware, however, that some modifications, depending on what those are, may violate other laws. For example, if you're modifying the firearm into an assault weapon or short-barrel rifle, etc. So apparently, based off of DOJ's position that we've seen that they've stated publicly, that these regulations only apply to changes made during the actual application process. And so there's nothing specifically prohibiting you under the law from making changes to that firearm, like, for example, if you want to switch out the upper receivers on an AR-15 style firearm after the actual registration process has been made. Just note, of course, again, that this is subject to change, so just be aware of that, that at least for the time being seems to indicate that the Department of Justice is suggesting that this regulation only applies during the application process. So that's essentially it as far as the actual requirements under the law and the regulations are concerned. I did want to address 3 specific questions that I'm seeing are sort of frequently asked by individuals that might have to register their firearms. So the first one, after July 1st, 2018, must you wait until DOJ approves your unique serial number application before doing any work to an unfinished frame or receiver beyond the point where it becomes a firearm? As I see it, yes. Specifically, I refer you to sections 5510 and 5518 of the regulations, which seem to indicate that you cannot go beyond the process of an 80% receiver turning it into a firearm until you receive that DOJ-approved serial number. One of the other questions that we get asked a lot, and I understand that there's some disagreement here, but at least this is how I see it, that what if I engraved a personalized serial number on a firearm made prior to July 1st, 2018 that is not already registered? Must I still obtain and engrave a DOJ-approved serial number on my firearm? As I see it, yes. The only firearms that are not affected by these requirements are those specifically listed, and so both in the Penal Code and in the regulations. And so if the firearm, for example, you might have your own unique serial number on it, but if that serial number is not one that's registered with DOJ in the AFS database, that is a gun that you are going to have to register according to these, according to the requirements of AB 857 and the accompanying regulations. And then lastly, must I immediately register a completed firearm lacking a DOJ-approved serial number built prior to July 1st, 2018, or can I wait until January 1st, 2019? No, you don't have to immediately apply for a serial number starting on Sunday. But again, just be aware that the January 1st, 2019 date is the cutoff date for any firearms that were manufactured prior to July 1st. And then, of course, sections 5510 and 5518 regarding those specific requirements. So that's pretty much it, guys. Again, if you have not already seen this, our office puts out a book called The California Gun Laws. There's a 5th edition that's available right now. This is getting updated regularly once a year, as far as I see it, with all the new laws and regulations that take effect or that at least change every year. So I encourage you, if you want sort of like a go-to source for any and everything related to California firearm laws, this is a great resource. I find myself using this in the office almost every day. So if you guys are looking for something that really sort of lays out, I think, in sort of plain English what these requirements mean, I encourage you to obtain a copy of that book. Outside of that, of course, I always encourage people both to join and support not only the CRPA, but of course the NRA. You can get more information on both the CRPA's website as well as the NRA's website on what you can do in your area as far as helping to preserve and protect the Second Amendment both here in California and throughout the United States. So I encourage you to, if you have not already, visit those websites. Make sure you're subscribed to email alerts. And if you're interested in volunteering, there are plenty of volunteer opportunities that you can participate in both through the NRA and CRPA. So with that, I think I'm going to, first I'm going to stop the recording. And then what I'll do is I will open up the floor here to questions that you guys may have, and then I'll pick out a few questions and I'll try and answer them to the best of my ability. So Grace, can we go ahead and shut off the recording here?